C'est innocent.
Hello,
En anglais.
good morning. Can you hear me on the English channel?
Yes.
Hello, good morning. Okay, I'll switch to French then.
Perfect. Oui, je vous entends. Merci beaucoup.
Order. Welcome to meeting number 100 of the House of Commons Standing Committee on Agriculture and Agri-Food. A few reminders, colleagues. We know this meeting is taking place in a hybrid format, and as you know, during the proceedings, those who are speaking will be the ones who are broadcast. Pursuant to the order of reference of Wednesday, January 31st, 2024, and the motion adopted by the committee on Thursday, February 8th, 2024, the committee is proceeding with its clause-by-clause consideration of Bill C-355, an act to prohibit the export by air of horses for slaughter and to make related amendments to certain acts. We do have a number of witnesses here today who can be called upon if needed. From the Canadian Border Service Agency, Graham Hamilton, Acting Director General, Traveller Commercial and Trade Policy Directorate. Kathy Tuxopus, I hope I'm getting that right. Okay, good. Director General Commercial Programs, Commercial and Trade Branch. From the CFIA, no stranger to this committee, Dr. Mary Jane Ireland, who is the Executive Director and Animal Health Directorate and the Chief Veterinarian Officer for Canada. From the Department of Agriculture and Agri-Food, Marie-Noëlle Desrochers, Executive Director, Supply Management and Livestock Policy Division. And from the Department of Justice, Guilton Pierre-Jean, Senior Counsel Legal Services for the Department, and Sheila Larmour, who is Counsel of Legal Services. So a number of people you can call upon, colleagues, if needed. I'll turn to my annotated agenda. I've already introduced our witnesses, our folks who can help, our experts. We do have our procedural legal folks here as well. So pursuant to Standing Order 75-1, consideration of Clause 1, short title, and the preamble are postponed. The chair calls Clause 2. Getting that right? Okay. Shall Clause 2 carry?
On division, Mr. Chair, or? Yeah.
Okay. Shall Clause 3 carry? Okay, maybe on division again, gentlemen, on Clause 3? Okay. Clause 4. That ultimately is something that has to be called, I have CPC 1 if you'd like to call it, Mr. Barlow.
Thank you, Mr. Chair. We do have an amendment on number 1 that I think everybody has in front of them. This provides that, I think it was quite clear from the testimony of all of the, or most of the witnesses that were spoke as part of the study for this this legislation or proposed legislation, that the end use of the animals going to Japan wasn't their concern. Their concern was animal welfare on the transportation of those horses to Japan. When questioned by members of this committee about their concerns with horse slaughter in Canada or for food in other parts of the world, that didn't seem to be a concern. So our questions were around, well, why isn't this the focus of this legislation more on the transportation and improving the regulations around the transportation of those horses? So if the impetus of this bill is to improve the health and safety of animals in transportation, which I think all of us would agree should be paramount, that we should be having the livelihood and the not the livelihood, but the animal welfare as top of mind when we're doing regulations, that this should be for all horses that are being transported by air. Certainly from Dr. Ireland, who was here, was quite clear in her testimony that that the rules for horses with respect to the movement, their transport, are the same regardless of whether the horses are destined for another country for whatever purpose. Whether it's for show purposes, a competition, or a feedlot, the same rules apply. And that is a quote from Dr. Ireland's testimony. I know that there was comments in the preamble, which we will get to, about cramped, which I don't feel is wording that should be used in legislation, but there has been no alternative proposed in this legislation in what should exactly be used. So if indeed the focus of this legislation for Mr. Lewis is to address animal welfare and the transportation of horses to Japan or any other destination, the focus should be on all horses, not just horses for slaughter. I think that is a misdirection, and I think if that's indeed the focus, then it should apply to all horses being transported by air, not just for slaughter, if that's not the focus.
Thank you, Mr. Barlow. So as all colleagues would know around the table, part of what our due diligence, and I say our, as the chair, I'm guided by our legislative clerk and our deputy legislative clerk to see whether or not the scope of the amendment is in order. And Mr. Barlow, you talked about the impetus of the bill. And again, I'm actually quite sympathetic to the argument that you're making around trying to improve, but I have had to rule on this bill. I've taken some guidance from the legislative clerk, and ultimately Bill C-355 provides for the ban of the exportation by air of live horses for the purpose of being slaughtered. The amendment proposes to allow for the exportation to happen under certain conditions, which is contrary to the principle of the bill as adopted at second reading at the House. As the House of Commons Procedure and Practice, 3rd edition, states on page 770, an amendment to a bill that was referred to committee after second reading is out of order if it is beyond the scope and principle of the bill. I'm of the opinion, and for the aforementioned reasons, the amendment is contrary to the principle of the bill and therefore is inadmissible. Now, I can be challenged on my ruling, and again, I want to make sure the record shows, Mr. Barlow, I'm actually quite sympathetic to the suggestion you're putting forward, but I am guided by what has to happen procedurally in this place, and I have been advised by our legislative clerk that it is inadmissible, and there is some flexibility for a chair on C-234, for example. I actually did not take the advice, but I think this is too far outside the scope of the advice I have been given, so I have to rule that this is inadmissible. But as I would say, colleagues, I am subject to be challenged, but that is the advice I've been given, and that's the ruling I've made thus far. Mr. McGregor.
I had a question, Chair, and maybe the clerk can help me answer this. If a committee, just hypothetically, if it ever did challenge a chair who had made a ruling on the admissibility of an amendment because it was outside of the scope, if that said bill was reported back to the House, would the Speaker then be compelled to intervene, ruling that the committee had strayed past its mandate and had ignored the second reading will of the House?
So, Mr. McGregor, this committee is well within its right to challenge the procedural ruling that's been made thus far. The only way in which a Speaker would then intervene would be subject to a member of Parliament raising on a point of privilege and suggesting that the committee had gone outside of its scope. The Speaker then would seek procedural counsel, whereas probably what I'm ruling right now would be upheld. I think actually that would be the case. So it really depends if any member of the House would choose to use parliamentary privilege if I was successfully challenged. Mr. Steinley, I see your hand.
As we saw in Bill 234, we can challenge the chair's ruling, but just put it to a vote so we can have on record that we had a common sense amendment put forward. And I think you're right; it is appropriate to have this conversation. And the vote, I'd like to have a vote on the ruling and see where that lands. But thank you very much for your comments; appreciate it. And Mr. Barlow has a comment as well.
Go ahead, I have Mr. Joanne, and then I'll go to Mr. Barlow.
Oh, I'm just saying we can vote. It's just the outcome will be the same in the House, even though we challenged the speakers would upheld the ruling anyway. So I'm just saying I understand where you're coming from, but the ruling would be the outcome would be the same, which the amendment would be deemed inadmissible in the House of Commons by the Speaker, I think is what I've is from what I understand. But we can vote on it.
Go ahead, Mr. Barlow.
Just on a procedural question with that, looking at Monsieur Perron's amendments 4 and 5, which also makes some changes to that in terms of adding to the scope of the bill in terms of feeding and watering horses during transportation, as well as having an attendant on the flight. I just wanted to the chair, if those two amendments are passed and would change the scope of the bill because they're specifically on that, would that change the position of our amendment? If you understand what I'm saying.
So without giving out future surprises down the line, basically the way it was framed to me from a procedural side, and again, I'm sympathetic to the idea of trying to allow the transportation under certain conditions, but the scope of the bill, the way it was drafted, is it's all or nothing. This bill is to prevent horses from being exported for slaughter for any reason. The amendments that are being considered in the package allow that to happen under certain conditions. And as you mentioned in your remarks, Mr. Barlow, you said, well, the impetus of the bill is to try to improve the travel. Mr. Lewis, or the bill is not drafted in a way that it allows for any provision of travel, and so it's quite black and white. And like I said, to Mr. Steinley's point, in other times that I've chaired, there has been a bit more of discretion, but in this case, the Legislative Council has been quite clear that this would be outside the scope, and I would be really stretching the bounds of my procedural authority in this committee. So although I'm sympathetic, there are a number, including Monsieur Perron's bill, which are proposed amendments, which talk about having adjustments and conditions attached that are ultimately going to be ruled outside of procedural order. Some of what you have put forward, Mr. Barlow, will be in order, particularly the adoption of when this would come into force. But the elements around trying to allow horses to still be exported with certain conditions or further parameters, the advice I've been given is that it is outside the scope of what the bill contemplates.
In saying that, and I appreciate your diligence, Chair, I still want to challenge your decision on this. Just as a matter of principle here, clearly what the witnesses were brought forward from the proponent of this legislation were so adamant that this was not about the end use of the horses. This was about the safety and the animal welfare. So I think that the misdirection of this legislation is what frustrates us, and for that reason alone, I want to challenge the decision and have it to vote.
Well, within the right of every member of this committee, and again, Mr. Steinley talked about C234 and others. There has been some discretion that I've allowed where it's been a little bit more gray. This was a bit more cut and dry based on the procedural experts that have advised me. So I will go to Mr. McGregor. There's not usually much room for debate, but this committee does operate quite well. We will go to a vote afterwards. Go ahead, Mr. McGregor.
Just a question, because sometimes the wording of what we're voting on could be confusing. Is this voting to uphold the chair's ruling? Like, can the clerk just explain what a yay-nay vote is in this case?
This is shall the decision of the chair carry. So Mr. Barlow would like to challenge the chair. So I guess as I understand it, if you're voting in favor, it's in favor to maintain the decision of the chair. If you're voting against, it's to overrule the decision procedurally that I've been given and to move on in a different direction. So Madam Clerk, I'll have you call the vote in favor of the chair or not.
Monsieur Drouin. Monsieur Carr.
In favor.
Monsieur Lewis.
In favor.
Monsieur McDonald.
I'll give you this one. Okay.
Madame Taylor-Roy.
In favor.
Monsieur Barlow. Monsieur Lew. Madame Rood.
Against.
Monsieur Steinley.
Against.
Monsieur Perron.
Contre.
Monsieur McGregor.
In favor.
Six pour, 5 contre.
Yeah. So ultimately, the chair's ruling is upheld by the committee. So unfortunately, Mr. Barlow, your first motion is inadmissible. Now, colleagues, it's very similar. So actually, sorry, Okay, so now that CPC 1 is ultimately defeated, CPC 4, CPC 5, CPC 6, and CPC 8 and 9 cannot be moved as they are consequential to the CPC 1 motion or adopt, sorry, amendment. Yeah. So CPC 4, CPC 5, CPC 6, 8, and 9 cannot be moved as they are consequential to CPC 1. So Conservatives 4, 5, 6, 8, and 9 would be inadmissible.
Monsieur le Président, j'aurais une question.
Question for the chair, please. So, with regard to CPC 9, you're saying it is inadmissible, but if the amendment proposed by the Bloc Québécois, the new one you received this morning, which replaces 4 and 5, now if that one were to be adopted, then the 9 would become more relevant, I believe. And I can see that it's been, there's a yes from you.
Okay. So we'll now move, I believe it's in our package, to the Bloc Québécois. First one. I guess it's 13016781. And colleagues, I can repeat it again, but very similar. And as I already outlined, or sorry, Mr. Parent, would you like to move your amendment?
Oui, alors j'ai bien compris que vous vouliez parler.
Yes, I understand you're talking about BQ1. So BQ1 proposes that section 4 should be amended by deleting line 12 of page 2. Line 12 of page 2 refers to pilots, and we Sorry, I was on the wrong channel. So I'll repeat. This makes reference to the amendment that was tabled this morning in replacement of BQ4 and 5, which then irrelevant, and we're sorry for the late submission of this form reformulation, and we think it would be more admissible in this form and in that particular place. So Section 4 of the bill should be amended by substitution to lines 5 to 10 of page 2 as follows. So number 4.1, it is prohibited to export a horse from Canada except if the person provides the minister with the written declarations, and also that the horse is not being exported for a slaughter. B, in case the horse is exported for slaughter or for fattening for the purposes of slaughter, I, that this horse will be accompanied by someone who's trained in order to feed and water and provide any care during the transportation. And double I contains a detailed plan for care provided to the horse during transportation. So here we're trying to work on the transportation conditions of the animal, which corresponds to the testimony that we heard here in committee. Thank you.
Just a second. Okay, Mr. Drouin, très rapidement.
Mr. Drouin, very quickly, please. So, Madam Clerk, if Mr. Perron's amendment is admissible, and correct me if I'm wrong, if my colleague's amendment, which amends lines 13 to 27, would it not be potentially inadmissible because we would be amending a line more than once?
Let me get there, Mr. Drouin. So yes, just in terms of, first of all, I will rule on the admissibility, which is going to be a problem. But yes, if this were to be adopted, Liberals 0.1 cannot be moved as a result of a line conflict. Mais premièrement, merci beaucoup, Monsieur Parent, pour.
Thank you, Mr. Perron, for your amendment in the same vein as Mr. Barlow, and because the amendment creates an opportunity for the exportation of horses with conditions, and the opinion of my clerks was very clear on the issue, because the amendment is outside the principle of the bill.
I'm sympathetic, Monsieur Parent, to what you're saying about trying to have further conditions, make sure that there is adequate care for the horses. But on the similar principle that I just read to Mr. Barlow, the advice I'm being given by the procedural clerks is that this is outside the scope, because the bill was very narrow in the way it was drafted, and it is black and white. Either you are allow the export of the horses for slaughter, there is no room. There is no room for conditions. There is no room for improving the way in which the horses. It is a very clear legislative bill that says this activity just cannot happen, regardless of whether or not there is other measures that can be taken. So unfortunately, this bill, I'm going to rule in the same manner, is inadmissible. I can read the text, but it follows the exact same procedural elements that Mr. Barlow's bill had. I can be challenged, and I invite you to do so if you'd like. I don't know if it'll change based on the last vote, but if you would like.
On va pas refaire le même vote trois fois.
Well, I think we're not going to do the same thing. Challenge the chair, and I'll ask a question to the analyst. Based on our analysis, as we were maintaining the prohibitions for transportation for the purposes of slaughter in the first paragraph, we thought that we could actually complement this bill. I mean, from point of view maybe of someone who's naive and not a legal mind, we thought this one would be more admissible because it would actually enrich the bill rather than contradict it. So, I mean, maybe you have comments to convince me to not challenge the chair's decision. Thank you.
Donc, le principe et la première clause dans le...
The principle of the first clause of this bill is very clear. It has to do with prohibiting the exportation of horses for the purposes of slaughter. And so, unfortunately, with the opinion of my procedural clerk as well as analyst, this amendment is outside the spirit of this bill.
I was asking similar questions as the chair of the committee yesterday. I asked a number of different ways, but I have to be guided in part, no matter how sympathetic I might be to the amendment that's being moved. I have an obligation to follow the procedural elements of this House and of parliamentary procedure, and the advice I'm getting is quite clear. There are other times that I've had a bit more discretion, where it's been a little bit more black and white, but unfortunately this is one that I'm being told would be precedent-setting. So I am willing to challenge. I am willing to be challenged based on the advice I'm given, but I don't know if the vote will be any different. So, what would you like to do next, Monsieur Parent?
Je ne ferai pas faire le même vote deux, trois.
I'm not going to put us through the same vote 2 or 3 times. So, yeah.
Okay. So we'll move forward then. We'll now move to Lib 0.1. That's you, Mr. Lewis. Would you like to move that amendment that you have put forward?
Sure. Thank you, Chair. And thank you for everyone for being here. This is Lib 0.1, is that right? Okay, thank you. It's a very small change, but it's something that we heard from a number of stakeholders. It just adds the phrase, or any other document that is satisfactory to the minister. It's a small change, but it amounts to a policy difference, and it's going to give flexibility. We heard the need for that kind of flexibility. Horses being transported by air for racing or equestrian events, recreation reasons. They already have documentation that could be supplemented easy. So this is, in effect, will help reduce the red tape and any unintended consequences.
Thank you, Mr. Lewis. Mr. Steinley.
Yeah, so just a couple questions, and Mr. Lewis. One is, like, what do you mean by any other document? Like, we showed cattle our whole lives, and we had registration forms and things like that. So, like, would a registration form from the breeder and showing that it's going to a show, or do you have, like, just some examples of some of the documentation? Because it's pretty vague, and I think if we're going to put this in legislation, it has to be a bit more clear, because that would be some questions I'd have off the top of my head right away. Just a couple of examples would be helpful to see where we're at.
Thank you. I didn't know if I had raised my hand. Thank you. That's a valid question, and that's why I left the flexibility with, it says, anything satisfactory to the minister itself. When we talk to horse racing, they have passports, and they actually have, the horses have a passport that could be somehow amended. When we talk to Equestrian Canada, I had many meetings with them, they have a lot of documents that simply would add another box to it, and instead of a declaration, it's just adding a box to an already existing document that's there, or something down the road. I didn't want to pigeonhole it into a specific document.
So then, would that be a list in the regs after? Because, like, the person's not going to send the registration or the document to the minister, and the minister's like, yeah, okay, and then send it back. Like, that's like a lot of red tape. So in the regs, are you thinking there'll be a list of what would be acceptable? So I'm just saying, you're not going to make it, basically the minister has to see the documentation first and then approve it, but there'll be a list of things that would be approved, and then they could show it at the airport.
Go ahead, Mr. Lewis, for what it's worth, and I'm not in a position to fully satisfy that question, but usually when the minister, we're contemplating obviously public officials and what that would, and I think you're right, Mr. Steinley, that it would follow some type of regulatory authority under the legislation that would allow, we do have officials here from Agriculture and Agri-Food Canada. Would we like to ask that question or have that directed? Maybe that's better directed to the officials. So,
to the pump there.
Mr. Hamilton,
Just a couple examples that would be considered, like the minister would consider that official documentation, so it's not more burdensome on the breeders for the transportation and like the documentation at the airport, so the airport officials don't. We heard from the pilots it's going to be much more strenuous for them and give them more roles and responsibilities that they don't want, I might add. But what would that type of documentation look like?
Yeah, perfect. Thank you very much for the question. Mr. Chair, the CBSA is responsible for administering over 100 acts at the border, and many of them have very similar vague language that is included in them. So, for example, into the IRPA, which allows Canadians and foreign nationals to enter Canada, people with right of entry into Canada do not need to show a passport. What they need to be able to do is establish their right of entry into Canada, and they can do that through a variety of different ways. Obviously, the one that's most familiar to everyone is just to show your passport. But if perhaps you lost your passport while you're traveling in the States, if you can satisfy a Border Services officer that you are in fact Canadian by showing driver's license or some other type of documentation, they will then rule on your admissibility into Canada. So similarly, in the amendment that's being advanced now, CBSA would be looking at the different documentation that's being provided, and we would probably lean into our CFIA counterparts in order to ask them to help us determine whether or not the documentation that's being provided is in fact satisfying the requirements under the legislation that we're enforcing at the border. So we would call over to our CFIA colleagues, and I think as we heard in the previous testimony, as live horses are exported from Canada, they are accompanied by inspectors from the CFIA, so we would engage with them in order to make a determination about whether or not that documentation that's being provided satisfies the requirement in the legislation. I hope that's clear. Happy to answer any other questions we have.
okay. Go ahead, Mr. Pearl.
Sorry, Chair. I just want to make sure that I'm clear here. To Mr. Lewis, you know, the concern that we had raised from folks was this additional step that the minister, there have to be a declaration to the minister. You know, in my opinion, you're making this more vague rather than more specific. I would have preferred you got rid of this entirely to add this additional step. We certainly heard from our conversations with the Calgary Stampede, Spruce Meadows and groups like that. This is going to be an onerous process for them to go through, and now it seems to be more vague. But maybe to Mr. Lewis, I'll ask if this passes and then we go to Lib 1, are you going to continue, like, you're removing the whole declaration of detention clauses on the pilots. why aren't you kind of doing the same thing with the steps you're asking the exporters to take on the declaration in this one? If that's a fair question to you. We certainly heard from the pilots that the onerous step or the onerous responsibility, and you're going to remove that, which I think is a good decision. We heard similar concerns with those organizations who are transporting horses not for slaughter, but you're not giving them the same respect, for lack of a better word, that you are the Airline Pilots Association, who had talked about the responsibility that's being imposed on them, but you're still imposing similar responsibilities and red tape on the exporters who are not, or transporters who are not moving horses for slaughter. They're still having to go through this declaration process. I would prefer that we just got rid of that entirely rather than adding to it.
If you'd like, Mr. Lewis, over to you.
We've got some experts here, but there just needs, we want to make sure that there's the tracking, basically a tracking of horses that exists already. And there needs to be a process in place, and this offers the flexibility down the road. And I think if we vote on this one, we get to Lib 1, it'll sort of, those two work together.
Go ahead, Mr.
Appreciate the conversation, back and forth respectfully. But the question is, Mr. Lewis, if we're going to ban the horses export for slaughter, there's already processes in place for other transportation of horses. So if that part's gone already, why the extra step? Is what I'm saying. Like what Mr. Barlow said is, you're taking it away from the pilots needing to do extra documentation. So if the ban of slaughter for horses for slaughter goes through, there's already processes in place for horses that are being shipped for other reasons. Why the extra step? Because the horses for slaughter is already done then, and that process is there. So I would say I don't think we need it, because it's just adding to a process that's already in place. If I have that correct.
Just say that this is there for enforcement and for tracking.
Okay, so assuming there's no other comments, I'm happy to ask the question of whether or not Lib 0.1 shall carry, and we can have a recorded vote. Recorded vote. Okay, go ahead, Ms. Clerk, Madam Clerk.
Monsieur Drouin.
En faveur.
Monsieur Carr. Monsieur Lewis.
In favor.
Monsieur McDonald.
Oui.
Madame Taylor-Roy. Monsieur Barlow.
No.
Monsieur Leroux. Madame Rood. Monsieur Stanley.
No.
Monsieur Perron.
Oui.
Monsieur McGregor.
In favor.
Obviously passes, yeah, 7-4. Thank you. Okay, we'll now turn to Liberal Amendment number 1. If you'd like to move that, Mr.
Thank you, Chair. Liberal 0.1 and 1 kind of work together. Liberal 1 will change the declaration from a requirement, which is what we heard, we were concerns about tying things up, for any horse shipped by air, to a reporting mechanism. So they work together. 0.1 and 1 work together. So it's a reporting mechanism that can be followed up for enforcement reasons, for tracking reasons. It's what the pilots, Equestrian Canada, Racetrack Canada, many of these organizations were asking for. So I believe this solves a lot of the problems, which you heard from good testimony from many stakeholders and good questions from our panel. Thank you.
Okay. So colleagues, just for your benefit, if this amendment is adopted, then BQ1, BQ2 would become mute and would not be able to be moved, and G1 could not be moved because of a line conflict. Monsieur Parent.
Well, as much as the responsibility is withdrawn from the pilot, I think the final objective is met. So we are not disturbed by that, if especially if the legal analyst can guarantee that the impact that we wanted to take the responsibility away from the pilot in terms of the paperwork is met here.
I think that'd be a question more for some of our experts here of whether or not that obligation is removed. This is more procedural. I think your question, Mr. Parent, about whether or not if Liberal Amendment 1 is successful, does it satisfy the concerns about eliminating the obligation to pilots? I'll maybe let one of our... do you have a question directed to any particular agency there?
Je voulais juste m'assurer. D'après moi, oui. Là.
For me, well, yes, the interpretation that I have, because it takes out the same line, so I think it should work in this case. Thank you for the question, Mr. Chair. I don't have a copy of the amendment, so if I could have the details of this exact amendment, maybe I could help with the question. Do you think it's necessary, Mr. Parent, or is it okay?
Non, c'est pas nécessaire. C'est les mêmes. Mes lignes, mes
No,
amendements.
it's not needed. I think the amendments are included here in the...
I don't think it's necessary. Monsieur Parent is satisfied. He was asking the question, of course, because Monsieur Parent had also similar amendments to try to remove the obligation to pilots. That will be satisfied with Mr. Lewis's. So that's why yours on block 1 and 2 would not be necessary because of this. And then also G1 would be, could not be moved because of a line conflict. Okay, seeing no debate, shall Liberal 1 carry? And I guess we'll ask for a recorded, or would you like to do it on division? Okay. Oh, Monsieur Parent?
Est-ce qu'on peut juste encore?
Can we once more another question? I'm sorry. I would like to have a response regarding G1 because I thought I understood that G1 was struck out from this proposal. Is it okay? Fine then.
Mr. Drouin, would you like to speak on G1 and whether or not there's a necessity to move that? Because obviously there is a line conflict.
I'm not moving G1, so I'm not going to speak to it.
Yeah, okay. Yeah, unfortunately, Mr. Parent, it can't be moved because there's a line conflict. So what I heard was on division, and we always work quite well in this committee on consensus. So we'll move forward. So Liberal 1 does carry, which then has impact. I now go to Bloc Québécois 3. Monsieur Parent, allez-y, s'il vous plaît. Si tu veux.
Mr. Perron? Well, that's my question. My doubts just got confirmed, and this amendment actually complements the withdrawal of any obligations to the pilot. So Section 4 should be amended by around line 22, page 2, as follows. The pilot piloting a plane with a horse on board for which no copy of declaration was received cannot be held responsible if they were authorized to pilot the plane. From the testimony we heard during the study, mainly from people representing pilots, they explained to us that a pilot should be in charge of the safety and respect of the schedule. And we would not want to add the responsibility of going to verify whether the authorization papers for the exportation of the horse are in order. So the pilot should not be held responsible in the event where it is proven that there was an illegal export. So this is an insurance policy aimed at ensuring that the pilot's obligations are not involved here. He's not responsible.
So I guess my first assumption is that since we have removed subsection 2, 3, and 4, this would be renumbered subsection 2 in, if adopted. And secondly, does this, if we were to adopt this, does it make sense adding it to the bill if there's none of the other stuff still in there? Is it kind of just floating by itself? That's my question from a from a legal standpoint to a jurlingus. Does it make sense to adding this section in if we've now removed the preceding 3 subsections?
So, Mr. McGregor, what this contemplates is the declaration, which still does exist in 4.1. So you're correct about the fact of it would now become 4.2 from a logical sequencing. If you follow me. So there's 4.1 in the bill, 4 subsection 1. Okay. Go ahead, Mr. McGregor.
Sorry, you said 4.1. We're still in clause 4.
4 bracket paragraph 1.
This would be 4 bracket 2.
Yeah. You satisfied?
Satisfied. Okay. But my question is, because we have deleted the previously existing subsection 2, 3, and 4, my question is, if we were to add this and it would be renumbered subsection 2, does it make sense given we have deleted the preceding sections, or is it just floating there by its own without, because we've removed references to pilots, right? That's what my question is.
Yeah, there's absolutely a removal. That's probably more a question for some of our experts in the department. I'll let you speak, Mr. Barlow, before we go there. And ultimately, a discussion we can have amongst lawmakers at the committee about if we're removing the obligations to the pilot, we don't have to contemplate liability to a pilot, because nowhere else does it say that a pilot would be actually involved necessarily in this process. I'm going to go to Mr. Barlow first, and then I'll come to you, Mr. Parent.
Thanks. And maybe this is for some of our experts here. I'm not a transportation expert, but because we are leaving in the declaration clause, no departure without declaration remains, and we removed the pilots, does there remain, or to our clerk, does there remain any liability on the air traffic controller, the marshaller, or does that have to be specified that because that no departure without declaration clause remains, and technically, an air traffic controller or an air marshaller would be giving permission for that flight to leave, is there any liability on them, and does that have to be specified in here?
I'm going to let our witnesses contemplate Mr. Barlow's question. I am going to go to Mr. Parent. I think it's an important point because it says no person to export. Question becomes, does a person include some of those officials you mentioned, Mr. Barlow? Mr. Parent.
Oui, en fait,
Well, yes, this comes back to Mr. Barlow's point. Since we maintained paragraph 4, which states that it is prohibited for a person to export unless you provide a written declaration considering the concerns expressed by the pilots. I think a law is never too clear, and if it is not specified, I have the feeling personally that a pilot could be targeted ultimately as being a representative of the airport. I think we should maintain this amendment unless I hear anything to the contrary.
Merci pour la question, Monsieur le Président.
Thank you for the question, Mr. Chair. Now, from my reading and understanding of paragraph 4, after the amendments that have been tabled by the Member of Parliament, MP Lewis, it states that it is prohibited for a person to export a horse from Canada by air unless they have, in the form and manner specified by the minister, provided the minister with a written declaration attesting that, to the best of their knowledge, the horse is not being exported for the purpose of being slaughtered or fattened for slaughter, as well as required with any documentation that the minister may require. So what I understand is that paragraph 4 establishes a formal prohibition to export for the purposes of slaughter unless written declaration is written to the satisfaction of the minister. By taking out paragraphs 4.1, 4.2, and 4.4, I think we can no longer mention the pilot or any other person. So in my view, it is the prohibition is for the exporter who will be acting contrary to this bill. This doesn't create any obligation for any other person besides the exporter.
So go ahead, Mr. Parent, and then I have maybe some thoughts.
Ouais, juste pour être certain de bien vous comprendre.
Just to be certain that I understand you well, Mr. Gilton, thank you for your clear response. So what you're telling us is that BQ3 is absolutely not necessary, pilots are not targeted by this bill, or should we amend the wording of the text to state that a pilot in command of the operator of an aircraft for which the minister has not received a copy of the declaration cannot be held responsible if they were authorized to pilot the aircraft? Would it not be judicious to specify this, or are you saying that it's absolutely unwarranted? Thank you, Mr. Chair, for the question. But from my reading of the text right now, the fact that paragraphs 4.2 completely disappears and there's no more mention of the pilot, the only liability here will rest with the exporter, who must provide a declaration that attests that to the best of their knowledge it's not been exported for the purposes of slaughter or any other document to the satisfaction of the minister. So there's no more mention of the pilot here. And in under 2, there was a responsibility from the pilot insisting that they receive a copy of the declaration. Now that it is struck out, there's no more obligation, no more liability for the pilot.
I think by including Yves' proposed amendment, it actually opens up the door to contemplating people beyond the persons responsible for exporting, who would be required to get a permit or authorization to submit something to the ministry. I think if you leave that in on the pilot, it opens up the door to who else could be potentially liable. But I would agree with Mr. Pierre Jean's proposition that if you read just 4.1, it is the person who is expected to export the horse would have to get permission from, or essentially would have to provide in a form or manner specified by the minister. But if we leave the piece on the pilots, it opens up, to Mr. Barlow's point, I think, other elements of people who are involved in allowing the plane to take off, which I think is far beyond the scope of what we intend to do. So I think, look, my advice as your chair, and you guys ultimately have the vote, is that you should just keep 4.1. I think perhaps we should drop the amendment, Mr. Parent. Obviously, all the blues and the testimony of this committee, if there was ever a challenge on the legality of it, it's going to be very clear that we were intending not to include other elements of the air travel supply chain, so to speak, that would be permitting the plane to take off otherwise. Go ahead, Mr. Join.
Pour suggérer à mon cher ami de juste pas.
I would suggest to not to withdraw the amendment, so we don't have to vote on it. It's just that considering the result of the previous amendment, now it is with the witness account that we heard, it is no longer needed. Thank you, Mr. Chair. If we're guaranteed that this is no longer needed and that there's no liability on the part of pilots, we can withdraw that.
On withdrawing it. Okay, we're good. So that's withdrawn. I do see your hand, Mr. McGregor, but let me go back to my procedural sheet here. So that takes us to the end of Clause 4 in terms of amendments. Was there anything you needed to say, Mr. McGregor? Okay, wonderful. Okay, so that brings us to the end. Shall Clause 4 as amended carry? On division? Okay. This brings us to Clause 4.1. This is Bloc Québécois Amendment 4. And without going into further detail, I will just reiterate that it's the same principle that has applied on the last 2 rulings the advice I'm being given on Bloc Québécois 4 is that is, of course, putting conditions on. But you go ahead, Monsieur Perron, if you want to explain.
Oui, désolé, peut-être ça n'a pas été clair.
Sorry, maybe this was not clear enough earlier. The amendment which was submitted at last minute was aimed at replacing 4 and 5. And the idea was to attempt in a way we thought would make it more admissible if this was not received. I think it would be the same vote that we're conducting twice. So we want to save time and move on to, and if we have unanimous consent, as I understood we need it, but that's it.
Need unanimous consent. I was just preempting what, if you did choose to move it, where we would be. So that will mean that we are now on clause 5. And this would be, I think, CPC 2, which was admissible. Mr. Barlow, if you'd like to, or whoever might want to speak on that, if you want to move it, go ahead. Over to you.
Sorry, you got me just as I'm.
You're getting a bite of lunch. Sorry about that.
That's okay. Sorry, Mr. Chair. Apologies. This one was admissible still? This was, yeah, thanks. We wanted to remove, because that declaration clause removed, we just want to make sure that there's no false or misleading information, and that it is prohibited for a person to provide false or misleading information or make a false or misleading statement in respect to any other matter related to the export by air of live horses, and that's really the focus of our amendment here.
That was premised on the idea that there would be an ability for a horse to move under conditions, which we ruled out of order. Would you still like to move that, or do you feel that it's okay?
Yep.
Yeah, and just for, as I was explained to me by the procedural clerk, this would apply to any horse being moved for in air, of course, outside of those being moved for export, because the bill is very strict on that. So it would talk about, as you can see from Mr. Barlow's amendment, anything that's misleading to any horse being moved in that context. So I'll leave it for any debate or open conversation, or we can call it to a vote. Okay. Shell CPC 2 carry. Do you need a recorded vote? I see Mr. Perron saying yes. The Conservatives are yes. Mr. McGregor, would you like to record a division, or how would you like to vote? Okay. So I guess on division, fortunately. Yep. Okay. So, yeah, it's defeated on division. Sorry if I wasn't clear. Okay, so this brings us to clause 6 and CPC 3. I believe this is admissible based on other elements. Okay. Go ahead, Mr. Barrow.
Yeah, we definitely heard about the onerous responsibility, again, that this legislation puts on exporters, on pilots, on those who are associated with the industry. And I certainly appreciate my colleague putting in some very stiff penalties. But again, this has now been banned. I don't think you're going to have any breeders now going to be in operation, which is going to be another consequence of this legislation. And the government's now taking on a multi-million-dollar liability here. But this amendment is just to lower the penalties for the offense under this act from $250,000 on a conviction on indictment to $100,000, and from $50,000 on summary conviction to $25,000. Again, just the feedback we had from testimony was this is a very onerous legislation, and I don't think the penalties to the height that they were necessary. So we just wanted to put forward reducing those fines to something a little more commensurate with what's going on.
Okay, colleagues, any discussion? Okay.
I guess I could add, too, that these are fines that were in line with what the Liberals put forward on 275. So they're in line with what he supported in a previous legislation.
Okay, if there's no other discussion, I will ask whether or not CPC 3 shall carry. Defeated on division again. I'm looking to some different folks. Abstention from Mr. Perron. You're abstaining as well. Okay. So it ultimately would fall on division. So there you go. So now I have to ask colleagues, shall Clause 6 carry? Ultimately, of course, Mr. Barlow was moving CPC 3. So now Clause 6, shall it carry? Essentially unamended. And I'm hearing perhaps on division. Okay. Shall Clause 7 carry? I will. On division, I'm hearing colleagues. I did miss Clause 5 on this because ultimately CPC 2 was not carried, but then I didn't say shall Clause 5 carry. I assume again on division. Okay. On Clause 8, CPC 4, we've ruled that that was inadmissible. That's part of the original decision, Mr. Barlow. So I will ask, shall Clause 8 carry?
Mr. Chair?
Go ahead, Mr.
Just before we get into Clause 8, I would ask just the rationale and whether or not we need Clause 8 and whether or not we need to modify paragraph 173C of the Customs Act. And I would ask folks from CBSA to just speak to that. And I'm just getting signal that it may be redundant, and I would propose that we strike Clause 8. But I will speak to the officials first and just ask questions whether or not this has any impact. If we do remove this, is there an impact to the Customs Act?
Perfect. Thank you very much for the question. Mr. Chair, because the information collected under this bill is not done so under the authorities of the Customs Act, by definition, it's not considered customs information. Clause 107 is specific to the authorities that the CBSA has to release customs information to other parties, including other government departments. And because the information collected would not be collected under that authority, it does not need to be in 107. If there is other information that's collected upon export that the CFIA would like to access, there are existing provisions within 107 that does allow us to provide that information to another government department upon request. So removing the reference to Bill C-355 in 107 would have no impact on CBSA's ability to share information with the CFIA.
Thank you. So, Mr. Drouin, I guess what I'm hearing from you is you may not be in favor of moving Clause 8 as is, and perhaps trying to strike it down.
Hold on. If I just, in terms of procedure, I can move an amendment to strike Clause 8, or we just don't carry Clause 8? Okay, perfect.
Okay, all those in favor to not allow Clause 8 to move, I guess, to strike down Clause 8. Okay, I see, yep. Okay, so Clause 8 will not carry. I'll now move to Clause 9. There was CPC 5. I believe that was inadmissible based on an earlier decision. Okay, so shall Clause 9 carry? On division, okay. Clause 10, CPC 6. I believe that was inadmissible as well.
My apologies, Chair. What happens with number 8? Okay, thanks.
Okay, so Clause 10, CPC 6 was deemed inadmissible, so shall Clause 10 carry? On division, okay. I'm now at Clause 11, CPC 7. I believe this is in order, so I believe so. I'm going to turn that over to you, Mr. Barlow.
Mr. Steinley.
This is an amendment to delay the coming into force of the bill from 18 months to royal assent to 5 years. Many stakeholders have told us how long it was going to take to have this. If this does come into effect, the effects it's going to have on their livelihood, on the gestation period of horses, unintended animal health consequences, and the fact that it will destroy people's livelihoods, forcing them to find other means to make a living, which could include retraining and other education for themselves. So although when the stakeholders were here that actually raised these horses, no questions were asked of them by any of the opposition parties, I think it is incumbent that we do think about the people that have put their heart and soul into raising these animals. It is their livelihood. It is part of their the past, but the present, but obviously not the future. This bill does come into force, and I think delaying this so we give the proper amount of time for people to figure out how it is going to affect their lives from here on out would be compassionate and something that this committee should take seriously, because it is going to affect the lives of a lot of people, and we should give them time to rebuild that life.
Okay. Thank you, Mr. Steinle. Any debate, any comments on the amendment proposed by Mr. Steinle? Okay. Seeing none, I'll ask whether or not the amendment shall carry. Would you like a recorded vote or just on? Okay.
I would love a recorded vote, Mr. Chair.
Okay. Go ahead, Madam Clerk.
Monsieur Drouin. Monsieur Carr.
Against.
Monsieur Lewis.
Against.
Monsieur McDonald.
Hey.
Madame Taylor-Boy. Monsieur Barlow.
Yes.
Monsieur Leroux.
Oui.
Madame Rood.
Yes.
Monsieur Steinle.
Yes.
Monsieur Perron.
Abstention.
Monsieur McGregor.
Against.
Unfortunately, Mr. Steinle, that amendment has failed, 6-4. So that brings us, colleagues, to Clause 11. Shall Clause 11 carry? I assume on division, based on our precedent. Okay, short title and the title, CPC 8 and 9, we're contemplating changes which ultimately didn't come into force. They're inadmissible. So shall the short title carry? On division? Okay, shall the title carry? Oh, shall the preamble carry? On division? Shall the title carry? I'm assuming on division. I'm going to keep moving through this, colleagues, unless you hear differently. Shall the bill as amended carry? On division, I presume. Shall the chair report the bill as amended to the House? I assume on division. And shall the committee order a reprint of the bill as amended for the use of the House at report stage? I assume on division. Okay, colleagues, thank you for, let me first, on your behalf, thank our officials for being here today and your work in your respective portfolios. Colleagues, I appreciate your work on this committee and the witnesses that have come before the House on this bill. We don't have anything else scheduled today, but go ahead, Mr. Barlow, very quickly.
Thanks, Chair, and just to the committee's indulgence on this bill, and I have spoken to the clerk on this. This was like something I have never experienced at this committee before, and perhaps it's happened at other committees. And I don't mean this as the members of this committee. I think we all get along. We get along very well. But when we were trying to work with potential witnesses to have them come and speak to this bill and really tell their stories about why this industry is important to them, how long they've been going on. It was, and I'm sure all of you had the emails in your offices that your staff had to deal with, which was, in my opinion, quite disgusting with how some of the activists who were pushing for this legislation were treating not only members of Parliament, but certainly the witnesses we had. And we had a number of witnesses that eventually decided not to appear at committee because of the intimidation and the reaction that they were getting from phone calls. A couple of witnesses had to call the RCMP on multiple occasions as a result of protests or intimidation at their farms or at their businesses. And I just want to mention to the committee here that unlike any time that I've seen that we've had witnesses that have refused to attend because of the threats that they were being thrown at them, I guess we'll say, and the harassment that they were having to endure from animal activists, which is really unfortunate, as I think no matter where you stand on an issue, you should have your voice heard and feel free to have that voice heard. And under the House of Commons procedure and practice, section 20, under committees and subsection related to witnesses, it states, and I want to quote this here, witnesses appearing before committees enjoy the same freedom of speech and protection from arrest and molestation as do members of Parliament. At the committee's discretion, witnesses may be allowed to testify in camera when dealing with confidential matters of state or sensitive commercial information. Under special circumstances, witnesses have been permitted to appear anonymously, which, thank you to the clerk, we were able to do. But tampering with a witness or in any way attempting to deter a witness from giving evidence at a committee meeting may constitute a breach of privilege. Similarly, any interference with or threats against witnesses who have already testified may be treated as a breach of privilege by the House. And committee, I just think that we need to set a bit of a precedent here that we always talk out in public how well we work together. And I think we should be sending a message to those who are involved in this industry or may have an opportunity to appear at committee that we are going to have their backs and we are not going to tolerate that kind of harassment and intimidation regardless of where we stand on an issue. Therefore, Mr. Chair, I would like to table this motion, a notice of motion, that the clerk and the analysts be instructed to prepare a brief report outlining the material facts of potential breach of privilege related to the reports of threats, harassment, and intimidation against and the efforts to deter the appearances of potential witnesses and witnesses in relation to the committee's study of Bill C-355, an act to prohibit the export of prohibit the export by air of horses for slaughter and to make related amendments to certain acts, and that the chair be instructed to present this report to the House forthwith. Again, colleagues, I was really disappointed to see how other Canadians were treating their friends and neighbors and certainly our agriculture sector simply because they didn't support what they were doing for their livelihood. And I think that was something I just wish we would never have to deal with, but it was a matter of fact in this case. And I can honestly tell you we had a number of witnesses who were scared, period, and did not want to appear at this committee to testify about this issue. And I just think that's not right. And if we truly want to go out there in the public all the time and say how well we get along, and this committee, unlike many others, does not have the shenanigans that it does. And again, I'm not saying this was anybody around this table's instigating this type of behavior, because I know that's not true. But I think we should send a message that that's not going to be tolerated, that anyone who feels that they have a position or feels that they feel welcome at this committee, and we will back them up. So I would like to move this motion and have this discussed today while we have an opportunity to do that. Thank you for your indulgence.
Mr. Drouin?
Yeah, I'll just obviously no witnesses should be bullied. I think whether it's on this issue or any other issue. So I would just say, Mr. Barlow, I support what you're saying. Regardless on, we know that debates sometimes get passionate, but witnesses should not feel intimidated when they come before our committee or don't come before a committee because they are being intimidated. But I don't want to specifically tie it to C-355. There has been other studies in front, and as an Ag Committee, I think all members of Parliament should encourage witnesses to come forward, and they should feel free to express an opinion without being bullied. I hope we could have dealt with this right away had some witnesses expressed. I'm not aware, but we did have some discussions about a particular witness appearing and not showing their particular face on camera because of she felt, the witness felt that there could have been some reprisals on that particular witness because of the opinion that they had. So I'm not sure what the report. I'm not sure what the report would say, other than obviously all members of Parliament condone bullying tactics by anyone. I think that's. I think from all sides we would agree, and I would challenge us as well as members of Parliament not to bully other members of Parliament when we have certain opinions as well. So I don't know what the consequences of that would be.
I'll let the clerk contemplate that. I see Mr. McGregor's hand, and then I see Mr. Perron. We'll let them weigh in, and we can get a sense of where this may go. Go ahead.
Thank you, Chair. Yeah, I mean, it's really important because like this committee meeting is happening in public for everyone to understand. Like privilege, it's not a term that many people like. It doesn't mean what many people think it means in a parliamentary context. Privilege is what allows members to be able to do our job on behalf of the people that we serve, but it also is a cone, a very important cone that extends to the witnesses who come before here. And as was demonstrated yesterday in the House, when the Speaker was instructing Mr. Firth when he appeared before the bar, anything that he said while presenting to the House could not be used against him in a court of law or in anything. That's the power of parliamentary privilege, is that even though these proceedings are held in public, nothing on this record could ever be used against someone. And we do that so that we can hear the unvarnished truth from witnesses who can give us their view on sometimes difficult subjects without fear of reprisal. I'm inclined to support this motion because I think it's an important principle to stand on. But I want us to be careful to not be selective in what we choose to direct our outrage as a committee against, because you know, I mean, one of my NDP colleagues had an axe thrown through his window from an Axe the Tax rally, right? That could be seen as a breach of his privilege, an intimidation of a sitting member to do his job properly. I think both instances need to be condemned, and we've, as a committee, have worked really well. I'm proud to be a member of this committee. Been proud to be a member of this committee for 6 years because of how well we work together. And we have dealt with some difficult subjects in the past. So I will be inclined to support this motion, but again, just with a cautionary note that we don't be selective in what we as a committee choose to investigate. This needs any chance that we get when there's been a breach of privilege. I think that's something that we as a committee have to be very vocal on. So I'll leave it at that, Chair.
Mr. Perron.
Oui,
Well, this joins in with some of the comments made. Of course, on the substance, we're not against the principle that people have to be able to come and testify at the committee without fear of reprisal. That's clear. It's unacceptable for members of the committee to be intimidated as well. Parenthetically, also, Chair, perhaps we could enable the witnesses that are here who have finished their duties in that regard. The chair is not hearing me. The witnesses.
To our good officials, you have good work to do on behalf of Canadians. You are certainly released. I'm sorry if I didn't make that clear. That got moved, and I was focused on Mr. Barlow. So thank you to our witnesses on that side. Okay.
I wanted to say at the start, but now I'm into the subject. So on the substance, it's a very serious matter, Chair. We cannot accept having people being bullied. With regard to public information and defending their rights and interests, whoever they are, we're in a democratic society. And we, in fact, deplored certain deplorable incidents in the social networks before the holiday season. But, Chair, before we say that we're going to do a report and present it to the House, I would like the committee to examine what exactly happened. Were there any complaints or reports to the police? I was not aware of it at all. Now I'm being informed of it here. It's a motion that I was not given in advance. I agree with it being presented today, but we could have perhaps received it before the committee meeting. And as I say, with regard to the underlying principle, I think that no one can disagree with it. We need to protect our witnesses, but perhaps we could ask for information. Perhaps we could pronounce ourselves on it at a future occasion before we send it to the House. If we don't have the conclusive information, I think we need to work in a serious and conscientious manner. I appreciate the intent of the motion, and I consider it important. So I would like to step back a bit and get the information, and we can pronounce ourselves on it on a later occasion.
Here's how I read the motion, colleagues. It asks, first and foremost, for the clerk and the analyst to be instructed to prepare a report outlining the material facts of what Mr. Barlow has raised. I presume then, once that report and that analysis is contemplated, if there's a majority of this committee who wants to instruct me as the chair to find that there has been a breach of parliamentary privilege, then I would report back to the House. So I don't read this motion as an absolute breach right away, and that I would report back right away, because to your point, Monsieur Parent, it first instructs the clerk and the analyst to prepare a report that then we would have to contemplate once that said report is done and when the information is pertinent to that. I am cognizant that this is an important discussion. I also know that there's other business we have to do. So I have Mr. Steinley, I have Mr. McGregor, and I have Ms. Taylor-Roy.
I would just say this, and I know that sometimes we want to expand the scope of some things, but we have specific evidence with the clerk and the analyst dealing with witnesses and conversations. So I think this can be something that is done relatively quickly. There is documented proof. They have had these conversations, and witnesses have put forward their concerns. There has been examples where they have gone to the RCMP, and quite a few of these are Indigenous women as well, Mr. Chair. Like, this is something that we need to take seriously. I would not want to see the scope expanded. There is documented proof with this specific bill, and I think we have a duty to make sure that people know that we're going to have their backs, like Mr. Barlow said. So I would not want to see this expanded. There are things on the table that we can, the clerk and the analyst can do their good work, bring a report, and we can look at it and see where we go from there. So I just worry that I wouldn't want to see growth in the scope. Like, this is something that we can look at very seriously and timely.
Yeah, I think it was just for the record that some of the colleagues were raising that. I mean, the motion is clear. But again, I want to make clear that the way I read the motion is that I'm not absolutely reporting back to the House. First and foremost, there has to be a contemplation of the brief that is submitted. Go ahead, Mr. McGregor.
Chair, I disagree with your reading, because I think the motion actually does instruct you to report it to the House. And I want to follow on Monsieur Perron's suggestion. I do believe it would be prudent for us as a committee to review this. So I would suggest an amendment to this motion. I would suggest that in the first line that the clerk and analyst be instructed to prepare a brief report for the committee, and then continuing on. And I would then, the next part of my amendment would be to delete and that the chair be instructed to present this report to the House forthwith. I think we as a committee need to be presented with this analysis and evidence first, and we can make a subsequent motion based on our review of those facts.
I've got Mr. Joanne and then Ms. Taylor-Roy.
To that point, if we are to eventually perhaps report back to the House, then obviously if the folks who have made these statements to our clerk, then I am interested in how do we protect them as well, because if we report publicly, we need to have a conversation about protecting those individuals that have made those particular statements. So I would be in line to supporting what Mr. McGregor said, and then maybe we can have a longer term conversation in terms of if we are to report back to the House, how do we do that, and how do we protect the identity of those that made those statements?
Okay, we're happy to contemplate that. So we do have the amendment as moved. So we're on that. Ms. Taylor-Roy, any quick?
Yes, and thank you. I think, Mr. Chair, this is a very serious issue, obviously, and we want to be sure witnesses feel free to come and speak and testify. I think there are ways to protect witnesses in camera and doing other things already, but certainly if they have received threats. I'm curious, though, Is this study specific to this bill, or will it also include other bills where we feel people have been harassed or bullied, such as perhaps 234?
The motion from Mr. Barlow, as presented right now, contemplates parliamentary privilege in relation to C355. And the amendment that Mr. McGregor has made is that the analysts and the clerks will prepare a report with the pertinent facts related to this particular study. And then, as Mr. McGregor has also moved, he has cut off the portion of the chair being instructed to present back to the House forthwith. That will become subsequent to the report being prepared.
I just think since it's such a serious issue that perhaps we could look at it on a broader basis, because I think we've seen evidence of bullying around other bills that we've considered as well, which we didn't study. So I'm wondering if we should perhaps expand it, especially if we're going to make a recommendation to the House around this, because I think we do want to protect witnesses and make sure that people aren't bullied.
Okay, so if you think, Ms. Taylor-Roy, that there's consensus in this committee to do that, you can move a sub-amendment to the amendment that Mr. McGregor has moved. I don't know if that's the case, but otherwise, where I'm at procedurally right now is that, assuming there's no more debate, what we would do is we would vote on Mr. McGregor's amendment, and then we would vote on, assuming it, depending on how that goes, then we would then vote on the main motion that has been brought by Mr. Barlow. I see Monsieur Parent's hand.
Oui, donc là, j'ai compris que l'amendement...
Yes, so I understood that the amendment from Ms. Taylor-Roy has not been introduced. Is that correct? Fine, because actually we're talking about 355 because we would have examples on that, but it's not restrictive. Perhaps just to reassure you, Ms. Taylor-Roy, I don't consider this as being restrictive. It's just that if we have concrete examples, we could take action based on that.
The motion is quite clear that it's in relation to Bill 355. But again, what I would suggest, and again, in the interest of time here, colleagues, what I would suggest is if we are of the view of letting the clerk and the analyst to prepare it, and we feel as though there had to be an expanded element, to your point, Ms. Taylor-Roy, down the line to say, okay, has there been other types of parliamentary privilege that have been breached at some point? This committee is well within its right to do so. But I will turn it over to you, and I am in the interest of trying to litigate this so we can move forward.
Yeah, thank you, Mr. Chair. I think that's a good point, and I agree, we have to have specific instances. But I'm just thinking the clerks and analysts may have heard from witnesses in other studies similar things. And if they have, I think that should be included, not just the one study. So if the clerks and the clerks and analysts know of other instances where there have been either witnesses or members that have felt they've been bullied and that has been brought to their attention, then I think we could include that in the report. So I'd like to see it a broader kind of, perhaps just in this session, indications that the clerk. So if that's agreeable to you, Mr. McGregor, to make it as a sub-amendment to yours, I would just broaden this a little bit.
It might be a different amendment altogether because Mr. McGregor didn't contemplate in his amendment actually amending the scope of the report that we prepared for the analysts. But again, in the spirit of this committee, Ms. Taylor-Roy, either you can move an amendment once Mr. McGregor's element is concluded. You can actually move another amendment to this motion, or this committee, which generally works pretty well in consensus, can contemplate what is before. And once the clerks and analysts come back, if we feel as though it has to be widened, we are well within our right to go further on that. I don't want to take too much more time. Go ahead, Mr. Barlow.
I just feel I should comment since this is something I raised. And this is a result of information and personal anecdotes that we've been sharing with the clerk throughout this entire process. So I wasn't doing this to make this a fishing expedition for other issues. This was just something that I've been here for a long time. This is I wanted us to deal with something specifically that has happened at this committee. I certainly don't recall another instance where a study that we've been doing at this committee where we've seen this type of vitriol, and certainly I know all of us were getting emails from people and pictures and all those types of things. And I guess my worry is that if we don't make a statement here, this will continue to proliferate, and this will be the signal we're giving that this is okay. You can treat people like this and treat potential witnesses like this. And how are we supposed to invite witnesses to come here and testify when we do have sensitive topics to discuss? And certainly animal agriculture is going to be one that is not going to end. These witnesses who have very important expertise to share with us are not going to come here if they don't feel that their testimony is going to be safe, they're going to be anonymous, or if they're going to be opening themselves to public harassment and intimidation. And so that's really why I had this focused on this particular issue. At committee with 234 here, we did not have that type of response from people at all. So that's why I want this focused. And just to Mr. McGregor's proposal for amendment, I'm totally fine with having the report come to committee, but I still strongly believe that this should be reported to the House because I think it's quite clear with the information that I've presented to the clerk over the last several weeks that this is an issue that was clearly a breach of privilege. I don't want to make that judgment, I guess, before everyone has a chance to see it. But I'm totally supportive of saying the report comes to committee first, but I still believe that the report should be tabled in the House.
And we can litigate that once the report is actually contemplated by the committee. I have Monsieur Perron first, and then Monsieur Drouin.
Merci, Monsieur le Président. Ça va être
Thank
très
you,
bref.
Chair. It'll be brief. In fact, I agree with what Mr. Barlow said with respect to Ms. Taylor-Roy. I do not think we should broaden it because we're asking for a significant job on the part of the analyst and the clerk to go in and get that information. And we cannot ask them today to go back and look at previous studies and find out whether they kept any trail of that. Let's start with this. And it doesn't apply to the bill, but rather to the study that we've just done. So we should not take it negatively as regards the bill, but it's important if we have testimony that Mr. Barlow stated, they have some aspect. We didn't see that. So what makes us hesitate today is that we didn't see that. We want to see it before we send it to the House. So I propose collectively that we vote in the amendment by Mr. McGregor and that we adopt a motion and settle that.
Amendment from Mr. McGregor. I'm flying blind, so I'm not comfortable with because I haven't seen anything. So we have not seen anything except for you for that particular slide. So I'm happy to get a report here, but after I want to make another vote whether or not we report this back to the House. So that's because I'm blind. I don't know what's don't know what's happened.
No, it was table dropped. I can reassure you, Mr. Drouin, that what Mr. McGregor is moving would allow the clerk and analyst to prepare a report of the relevant facts and information, and then the committee can then further determine whether or not there is a breach of parliamentary privilege. So I am going to, okay, go ahead, Ms. Taylor.
Yes, again, I haven't seen the motion, the amended motion right now either, but my concern is that if this is a broader issue, I want to ensure that we do look at the broader issue if it's established here. I mean, part of the problem with this conversation is that apparently members opposite are privy to information that wasn't shared with us earlier. So we don't really know what they're talking about or the extent of these threats and allegations. So I'm fine to have a report, but I just want to ensure that if this is happening, and in fact, the clerks and analysts have heard from other witnesses similar kinds of concerns prior, or from other people that they've been bullied, that we do expand it to that. And I don't think we need to specify this bill in this motion in order to do that. So I think there's a real concern about witnesses being free to testify, but I don't like tying it to this particular bill because it puts a, it kind of makes it sound like this bill was the problem when there are many other bills where similar things have happened. So that's my objection.
So what I would say is, having sat as the chair of this committee for 2.5 years, there's never been another instance that I can contemplate that there was a witness who asked to not be identified. We take pretty seriously our role that if there is type of harassment or the chair of the committee nor can the clerk or the staff contemplate the World Wide Web and what goes on outside the four walls of this committee. So I think it was relatively it doesn't happen often in terms of witness witnesses wanting to speak without being identified. I take your point, Ms. Taylor-Roy. I don't know of any other instances, but I do want to allow us to ask the question about whether or not we want to move forward with Mr. McGregor's amendment. And I do want to make sure that nothing is going to be reported back to the House at this point if Mr. McGregor's amendment is ultimately done. Now, if you guys want, we can stop the clocks, we can go print this, and we can have it back if you feel it's necessary so that you have the opportunity to see the amendment. I'll look to Mr. Joanne. Is that necessary?
I'm fine with. As is.
I don't think.
If the other side agrees with Mr. Barlow's amendment, then we're good to go. Yeah, Mr. McGregor's. Yeah.
Vote on it as amendment. Approve Alistair's amendment that the report comes back here before going to the House.
I don't want to send a report to the House where I don't have knowledge on it, so I want committee.
And then we'll vote a second time.
Okay, that's fine.
Yep.
That's fine.
I don't want to. Look, it is crystal clear to me as the chair. So if we are okay to move Mr. McGregor's amendment to what Mr. Barlow moved, what that would then precipitate, what that would mean is the clerk and the analyst will go do the work. We will contemplate this further down the road when they have the time to do it. If we feel there's enough information and evidence that is provided that you want me to report back to the House that we feel as though there's parliamentary privilege has been, because I don't have the ability to, that's to the Speaker. I'm not sensing any concern, and we will come back to your point, Ms. Taylor-Roy. If you want to amend the motion, you can do that today. But I'm not so sure that there is a majority that will support that. But there's nothing contemplating, stopping us from contemplating that down the road when we hear, and we perhaps go in camera to hear the information. You can ask those same questions to the staff that advised me about whether or not there is more to that should be done, and the scope of this should be widened. Go ahead, Mr. Kerr.
Yeah, I just want clarity, please, Mr. Chair, on something. Assuming for a moment we adopt Mr. McGregor's amendment, the clerk takes this away, a report is brought back, we hypothetically, as a committee, vote down whatever comes from that, the prospect of reporting it to the House. Okay, that's the context. So my question within that context is, would the contents of the report, even without a submission to the House, be publicly available? That's my first question. Number two, would it be available to the Senate committee? And if so, eligible to be discussed in the context of the bill when it gets to the Senate's consideration of it?
On the first question, Mr. Carr, no, it is up to the majority of the committee, so it would not be shared publicly. On the relation to the Senate, I don't know if I have that answer at this point.
I think that's an important question.
We'll have to do research and report.
Okay.
But again, a committee is a master of its own domain. What I would say, if we choose not to have any of that shared, I'm quite confident on the public piece. I don't know about the Senate procedure, so I don't want to speak on that. But generally, parliamentary committees are, with consensus, able to choose to do whatever the hell we want within reason. Go ahead, Ms. Taylor-Roy.
I think there's consensus that we move forward on what Mr. Barlow has put forward. I do not feel comfortable voting on this when I don't have it in front of me with the amendments and when we don't know how this material will be used. But I think we have consensus, so I suggest that if we want if the Conservatives would like an official vote on this, that we wait until the next meeting. We have the amendment printed and put before us, and then I may make a sub-amendment at that point to it. But right now, I think if we want to just go ahead and proceed with this as there's consensus in the committee like we often do, then I think that's fine.
The motion has been distributed to everyone's personal account now. We could just move the motion on division if you're not comfortable in having a specified vote, Ms. Taylor-Roy. But I do think there's a consensus to move with what Mr. McGregor has proposed. Are we good? So on the amendment to Mr. McGregor's amendment, it's simply he has moved for the committee and has scrapped the part at the end, which is, and that the chair shall be instructed to present the report to the House forthwith. Mr. McGregor rightfully has, I think, identified the fact that he doesn't want to give the pretense that absolutely I'll report back without having had that report prepared and analyzed by this committee.
Mr. Chair, where was the amendment sent or the motion sent? I
The
don't have it.
motion was sent to everyone's personal email account. If you'd like to suspend, I can do so, and we can, okay? Everyone should have it in their email account as of about a minute ago. The clerk
And do
was
we
working.
also have Mr. McGregor's amendments to this, the amended version?
If you would like, we can suspend, and we can make sure it gets translated and everything on that side.
Yeah, just the one quick question. The motion as is, it hasn't been modified yet with Mr. McGregor's amendment.
I'll make this very clear to all my colleagues. So I will read it out in English very slowly for everyone to understand. That the clerk and the analyst be instructed to prepare a brief report, and this is where it's amended, for the committee, outlining the material facts of the potential breach of privilege related to the reports of threats, harassment, and intimidation against, and efforts to deter the appearances of potential witnesses and witnesses in relation to the committee's study of Bill C-355, an act to prohibit the export by air of horses for slaughter and to make related amendments to certain acts. And then it is stopped there. And this is to Mr. Jouin's point. Mr. Barlow's original motion contemplated this passing right away and that the chair be instructed to present the report to the House forthwith. That has since been amended by Mr. McGregor that we will consider the report that has been prepared and then ultimately make the decision of whether or not you would instruct me to go to the House after that.
And I'll just note on that, that yesterday, whether we agreed or not, was a form of bullying on a private citizens than what happened in the House of Commons. And I'm just, we're dealing with this today, but what happened yesterday, I wasn't in the House. I want no part of it because we have authorities that deal with this kind of stuff. So again, when we're going to have to rule on whether harassment was done or not, I'm going to have to, are we going to invite the HR expert or something to determine that?
So, Mr. Jouin, again, the committee, what the instruction is that the clerk and analyst will prepare a brief report outlining what is the facts and the material element of what is being alleged in the motion that is presented by Mr. Barlow. We will be free to ask questions. We will be free to bring other individuals as we see fit, because this committee is a master of its own domain. So that will be completely up to you and anyone else on this committee about how we want to handle what would then be subsequently prepared by the analysts. And whether or not we choose to find there is parliamentary privilege ultimately is not our, if we feel as though it has been reached based on the definition, you can then instruct me as the chair to go back to the House on that, or you cannot. That will be up to this committee to decide, including the parameters of how we determine that, which will be, I presume, an in-camera setting. Again, something I do. So I want to deal with what's here. It seems as though there's a majority that agrees with the approach that has been proposed, and I don't want to spend too much more time because we are coming to a close. And I know, Mr. Lewis, you want to move something as well. So any further? Go ahead, Ms. Taylor.
Yes, I'll just repeat that I think this is a very important issue. I agree with you, Mr. Barlow, that witnesses should not be intimidated, and we don't want to see bullying at all. I think it is. I think the problem with this motion, though, is we have in here a potential breach of privilege. I don't think we've even established. You said that you thought the privilege of members of parliament extended to witnesses. It wasn't very clear on how it does. But I think there's a lot of things around this, and what are the repetitive threats, harassment, and intimidation? Again, how are we defining those? What do we think those are? I mean, I'm all for doing some kind of a investigation into this. I don't know it's committee business, and I don't know it should be related to the study of Bill C-355. I think it should be broader if this is happening. And when you asked to have, or when the witness asked to come to committee and have their identity protected, we were told that this had been done in other committees before, that this type of procedure. So certainly there are other examples in other committees of instances where people felt that they needed to be protected before coming to witness. And there is the ability to appear in camera that is provided, and I'm presuming that is also because of those same considerations of privacy or perhaps fear of intimidation. So I feel that this is an attempt to link this to Bill C-355 in particular. And I don't believe it is an issue that is only specific to Bill C-355. And I think that this has the potential to undermine in some ways the bill. If you'd like to remove, the reference to Bill C-355 and make this broader, which I think addresses your concerns, I'm more than willing to do that. I just do not want to see this in any way targeting this specific bill.
Colleagues, I do want to move, I take the points that have been raised. Ultimately, pending there being another sub-amendment to what Mr. McGregor has moved, I would like to call the question on whether or not, and if we need a vote, we can, and if people need more time to contemplate it, I can work to suspend, but otherwise I would like to just call the question. To your point, Ms. Taylor-Roy, if we go down this study, which Mr. McGregor's amended motion would contemplate, if we feel as though there is other instances, we are well within our right to report back in a way that includes those elements that you said. So, I don't.
Do you want to suspend?
Not necessarily. I'm going to go to Mr. Liu. If you guys want to continue to consult, go ahead.
Merci, Monsieur le Président. Je pense qu'on a fait le
Thank
tour
you,
de la
Chair. I think we've covered the issue
motion amendée de
with the amended motion from Mr. McGregor. I would ask that we vote.
I think it was a deleterious motion, correct? So I think we have to go to, I think you just moved a motion to go directly to a vote. Ms. Taylor-Roy, I'm going to give you just a few minutes to get back to your seat so that we can allow for the vote to be called.
Do you want to just repeat the amendment?
Ms. Taylor-Roy, I'll have to, there has been a motion moved. I have limits in how long I can delay that for a vote. So
You want to repeat what we wrote?
I will repeat it, yes, just, yep. So colleagues, there will be a vote, and it is on the amended motion from Mr. Barlow that the clerk and analyst be instructed to prepare a brief report for the committee outlining the material facts of the potential breach of privilege related to the reports of threats, harassment, and intimidation against, and efforts to deter the appearances of potential witnesses and witnesses in relation to the committee study of Bill C-355, an act to prohibit the export by air of horses for slaughter and to make related amendments to certain acts, period. I'll call the vote.
You want to call the decision?
Yes.
Monsieur Drouin.
As amended, right?
This is on Mr. McGregor.
Okay, en faveur, en faveur.
Monsieur Carr.
Yes.
Monsieur Lewis.
Yes.
Monsieur McDonald.
In favor.
Madame Taylor-Roy.
I just want to be clear, this is on the amendment, correct? Yes.
Monsieur Barlow.
Yeah.
Monsieur Lehoux.
Oui.
Madame Rood.
Yes.
Monsieur Stanley.
Yes.
Monsieur Perron. Monsieur McGregor.
Yes.
Okay, colleagues, so that's unanimous. So now the motion by Mr. Barlow is adopted, or is amended with Mr. McGregor's element. So now technically, assuming we need it, I can call the vote on the main motion. Assuming no other debate, I'm going to call the vote on the main motion.
En faveur.
Monsieur Drouin.
En favor.
En faveur.
Monsieur Carr.
In favor.
Monsieur Lewis.
Yes.
Monsieur McDonald.
Oui.
Madame Taylor-Roy.
Against.
Monsieur Barlow.
Favor.
Monsieur Lehoux.
Oui.
Madame Rood.
Yes.
Monsieur Stanley.
Yes.
Monsieur Perron.
Oui.
Monsieur McGregor.
Yes.
Okay. Obviously, colleagues, that passes. Mr. Lewis, you have the floor very quickly.
Thank you, Chair. I want to thank everyone. And yes, this committee does work well together. And I put a notice of motion the other day. I hope everyone got it. So I'd like to table that motion. It's about protecting farmland. And I think this is the perfect spot to do that. Many of our members are here from Ontario. We know that in Ontario, we're losing about 319 acres a farm every day, and only about 5% of Ontario's landmass is suitable for agriculture. So my riding, Kitchener-Conestoga, is at the heart of Ontario's agricultural land, and we're facing farmland loss right now. So as Canada grows, we have to do things and do so while protecting prime agricultural land. So I believe that all levels of government can collaborate in a nonpartisan manner to preserve farmland for today and for future generations. So I'm going to table this motion that says, pursuant to Standing Order 1082, the committee undertake a study on the protection of prime agricultural areas for their long-term agricultural use, the use and/or development of agricultural land as defined by Canada Land Inventory for non-agricultural development, and that no fewer than 4 meetings are set aside to hear from witnesses, that the committee report its findings to the House, and that pursuant to Standing Order 109, the government table a comprehensive response to this report. So in the interest of time, perhaps we can talk about the details of how many meetings and when that happens in a subcommittee, but I thought it was important to table this now.
Yeah, we are getting tight on time. And by the way, we didn't have the opportunity to say congratulations. The bill did pass in your name. We moved to a point of privilege. But I hear you moving it, but you are okay for us to wait another day to determine whether or not we want to move forward. Monsieur Parent, I saw your hand, but perhaps where Mr. Lewis is willing to engage on this topic in another day, we can go. Go ahead.
Oui, c'est une bonne chose. C'est ce que
Yes,
j'allais-
it's a good thing. That's what I was going to ask to do another day because farmland protection is essential. However, it's 100% under provincial jurisdiction and under Quebec's jurisdiction. So your motion today, if you vote, I would have to vote against it. I invite you to consult the members of the committee and to look into it if you can find some formulation that could be acceptable. But in that topic, it will not be easy for us.
Go to question period.
Yeah, similarly, I think the idea has merit. I would vote to adjourn the debate on this because I need more time to contemplate it. But in British Columbia, we have the Agricultural Land Reserve. Like, I don't know of any opportunity where the federal government can get involved in the province of BC. That is entirely under the province to protect. It's under legislation, has been since the 1970s. So I think it's a good idea, but I think there's a number of motions that are on notice right now, and ultimately, Chair, I think we need to have a subcommittee meeting to try and do some air traffic control on this. Yeah. So thank you.
Okay, colleagues, we will do that. And as you know, now that we have finished 355 on the clause by clause, my intention, as you instructed the other day in camera, is to move to the contemplation and the finishing when we come back from the break week on the study on food price stabilization. So that will be the Tuesday. We will get that report done. I will be happily work with my vice chair, my two vice chairs, and Mr. McGregor and Mr. Drouin to identify where you might want to go next. We are getting at time, and so assuming there's not any other urgent elements, I would move to, I'm happy to basically knock the meter. But I'm going to go to you, Yves, very quickly, and then I'm going to hit the hammer and we're getting out of here.
Monsieur le Président, de votre
Thank you, Chair, for your latitude. I would just like to be sure. You mentioned the study on food inflation. So we invite committee members for the negotiation of the Code of Conduct. Is that correct?
It hasn't yet been scheduled. That motion has been moved, and we were a little bit dependent on what was going to happen today. We now have a clear line of sight of what the next couple of weeks look like. As I just mentioned, I will work with you, John, Francis, and Alistair, and we can figure out what the schedule looks like for the next couple of weeks. I know that's a priority for you and this committee. Okay, meeting adjourned, colleagues. Thank you.
Merci.